We've previously discussed the issues and provisions related to the West Virginia Freedom of Information Act, FOIA. Our primary concern has been the requirement for citizens to forfeit their Fourth Amendment rights to access public records. This time, we want to focus on the appeals process for denied requests. Let's start by reviewing the key points from the introductory provision of West Virginia's Freedom of Information Law. Pursuant to the fundamental philosophy of the American constitutional form of representative government, which holds to the principle that government is the servant of the people, and not the master of them, it is hereby declared to be the public policy of the state of West Virginia that all persons are, unless otherwise expressly provided by law, entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments of government they have created. To that end, the provisions of this article shall be liberally construed with the view of carrying out the above declaration of public policy. Despite the claim made in this provision that public servants do not have the right to decide what information is good for the public to know, we would argue that the lack of a free non-judicial appeal process has the real-life implication of doing exactly that. Let's discuss how this provision applies in practice. As you'll see, the current law effectively favors affluent citizens over the everyday, struggling residents of Cabell County. In many states, such as Alabama, Alaska, California, Florida, Illinois, New York, Texas, and others, the state code outlines an appeals process that allows requesters to appeal denials with a variety of options, such as to the specific agency denying the request, to the state's attorney general, to an appeals officer, to a public access counselor, or another non-judicial entity. These steps are services provided free of charge to the public. However, in a few states like West Virginia, citizens must file costly legal actions to appeal a denial. A fact that has a chilling effect on the ability of many citizens to conduct oversight of their state and local government. Imagine you need or want public information and submit a Freedom of Information request, only to have it denied simply because a public official doesn't want the information released. What recourse do you have as a citizen? In West Virginia, your first and only option is to file a costly claim in Cabell County Circuit Court. As shown in this screenshot, filing in Cabell County Circuit Court can cost over $200 just to file, not including any attorney fees. At a time when most Americans are struggling to meet basic necessities, this obstacle effectively excludes a large segment of citizens from access to information at the whim of the public official. To make matters worse, the public official who denied the records may face no real consequences. Even if the court orders the release of the records and the official complies, West Virginia Code states that anyone who willfully violates this law will only be fined between $200 and $1,000. If the official releases the records at the court's behest, they may face little to no repercussions for the initial denial. Meanwhile, you are left to cover court and legal fees that could easily amount to thousands of dollars, unless the court orders these fees to be paid by Cabell County taxpayers. In essence, there may be little to no penalty for a public official who initially withholds information, hoping that you can't afford or won't pursue a court claim to obtain it. However, there may be significant consequences for the taxpayers if ordered to cover the court and legal fees of the claim. This situation not only leads to unequal application of the law but also allows corruption to go unnoticed and unchallenged unless you can afford to risk hundreds or even thousands of dollars on a legal claim. Further, there is no management or tracking system at the local government level for request denials, leaving taxpayers in the dark as to the real extent of the problem. Let's consider a recent example. A Cabell County citizen requested details about funds the city of Huntington spent on a specific law firm for the defense of a public employee's actions. Assistant City Attorney Sam Ranspatom denied the request, citing attorney-client privilege. For clarification, attorney-client privilege is a legal concept that protects communications between a client and their attorney, ensuring that such communications remain confidential. However, this privilege should not extend to receipts for taxpayer money paid to a law firm for legal fees paid in defense of a public employee's actions. Due to the lack of a non-judicial appeal process, the only recourse for the citizen is to file a costly legal claim, further burdening Cabell County taxpayers. Contrast this denial with an earlier incident where Cabell County Administrator Beth Zirkle released documents showing that Cabell County paid $38,000 in legal fees for the defense of the Cabell County Clerk and Commissioners. If legal fees are covered by attorney-client privilege, why was this information released? Was it a legitimate disclosure of legal fees, a breach of attorney-client privilege, or a waiver of such to enable a political hit piece during a contested primary? Similarly, in 2021, ACLU investigative reporter Kyle Voss faced an issue when attempting to obtain records from Cabell County's 911 center through a FOIA request. After waiting a month well beyond the mandated 5-day response window, Mr. Voss contacted the 911 administrator's office and was told he would need to file a subpoena to access the public records. According to a lawsuit filed by the ACLU on his behalf, Mr. Voss tried to engage in further dialogue with the agency following the denial. However, with no legally binding requirement for the agency to respond to his appeals, he received no response to multiple follow-up emails and phone calls. His only recourse was legal action. Thankfully, with the ACLU at his back, he had the financial ability to take that step. The work of investigative journalists like Kyle Voss is crucial for protecting our democracy and citizenry. Through his reporting and research, Kyle has uncovered significant issues, such as the systemic denial of prescribed medication to inmates in West Virginia jails. The issues he and other journalists investigate can profoundly impact our local community. Public servants and their agencies stonewalling or standing in opposition to such research without facing any repercussions is unacceptable. These situations highlight the inconsistency in handling FOIA requests within our county, and they represent just a few examples among likely hundreds, if not thousands, across the state. The free availability of public information serves the public good, and the right of public oversight is a right granted to all members of the public. However, having the right and the ability to exercise that right are two different things. Public information belongs to everyone, not just those who can afford the litigation needed to obtain it. If state legislators are serious about free access to public information and rooting out corruption at the local and state levels, they should take a long, hard look at the enforcement and tracking of FOIA compliance within the state and the strength of its compliance and appeal provisions.